following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain estate planning after a divorce. Let's first talk about why estate planning is particularly important after a divorce. Whether or not you have an estate plan, there's a real chance after your divorce that your ex is going to get control of your assets unless you reevaluate your estate plan or put one in place. If you don't have an estate plan, or if you have a will but not a trust and you have minor children, there's a scenario where everything that's intended to go to your children might actually get to your ex, and your ex has control of those assets. Let's talk about that. If you die without a will and you're not married and you have children, then in Illinois state statute says that everything's going to go to your children. If you have a will, you're probably leaving everything to your children. The issue is that if your children are under the age of 18, they can't inherit property directly. Instead, what happens is the court will set up a guardianship of their estate and appoint a guardian of their estate to manage the assets that they inherit for their benefit until they reach the age of 18. So the problem with that is that your ex, as their parent, is probably going to end up being the guardian of their estate. And this means that your ex is going to basically have control of the assets until they reach the age of 18. Now, the ex is supposed to manage those assets for the child's benefit, but there's not a ton of oversight there and no guarantee that the ex isn't going to basically treat those assets as his or her own. And that's not a situation that most people want. So the way we get around that is having a good estate plan. What we do is put in place a revocable living trust. A revocable living trust is a legal entity that can own property after you pass away. So everything that was in your estate will go into the trust. You'll name a trustee who's not your ex, somebody you trust, maybe a family member, a sibling, that can manage the assets for your child's benefit until the child reaches whatever age you would like the assets distributed to them. During that time, the trustee has the discretion to either dispense those assets for the benefit of the child if the child needs them, or not. So basically you're giving the power of the purse strings of your estate to somebody that you want to have that power rather than to your ex. And that solves that problem. The other issue is that even if you have an estate plan, you've probably got your ex listed as the primary beneficiary and fiduciary on that estate plan. And what that means is that your ex is probably the person that is listed as the executor of your will or the trustee of your existing trust, and that's the person responsible for managing the assets when you pass away and making sure they get to the right people. You probably don't want him or her in that role, so you want to make sure that you update your will and or trust to remove your ex from that role and put somebody else in that role. Also, your ex is probably listed as the primary beneficiary of your will or trust because they were your spouse. So just to make sure that they don't inherit everything when you pass away, you want to make sure that you remove them and put somebody that you want to inherit your property as the primary beneficiary of your will or trust. If you have a healthcare or financial power of attorney, your ex is probably listed as the agent that's responsible for making financial and medical decisions on your behalf if you're mentally incompetent. So you want to make sure that you put somebody that you want in that role and not your ex. Whether or not you have an estate plan, you probably have your ex listed as the primary beneficiary of your life insurance policy or your retirement accounts, and you want to update that and remove them, and also make sure that they're removed as the beneficiary of any other payable on death accounts that you have. So any checking or savings account that's payable on death to your spouse, make sure that you remove that designation, and if you want, make it payable on death to somebody else. So lastly, let's talk about what happens if you remarry. This is where estate planning can get really creative, because mixed families with children from two different marriages often want to ensure that each set of children inherits their parents' estate after both of the spouses have passed away. So you're in a situation where you don't want it to be a game of which spouse survives the longest and their side of the family is going to get everything. And you can use trusts creatively to make sure that during the lifetime of the surviving spouse, they'll have access to any assets or real estate that they need, or at least a certain portion of those. And then after the surviving spouse passes away, both sides of the family are going to get everything equally, rather than the surviving spouse's own children getting everything from both sides of the family. So trusts are really important in that situation, and that's where we bring in irrevocable trust and get really creative and tailor the trust to the particular family situation to make sure that everybody, both the surviving spouse and the children on both sides, are treated fairly. So thank you so much for listening. If you have any questions, please give us a call at 630-324-6666. We offer free consultations in most areas of law. Please subscribe to us on YouTube, SoundCloud, and iTunes. Thanks.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.